Hello, my name is Mande Ndema. I'm a director of Mdyesha Ndema Attorneys, and this is my partner Sbongile Mdyesha. We are today here talking at the Capitec Live Better talks, talking to idols, contestants, the top 16, talking to them about their contracts, legal contracts that they are about to enter into as they enter into stardom. I'm sure you guys have signed contracts in your lives. And what does a contract mean in a nutshell? It means it's an agreement, and that agreement can be between two or more people. Out of that agreement, there must be a commitment, there must be an obligation that comes out of it. In a nutshell, whatever happens, any contract has got to meet these requirements. In the middle is a contract, and then on the left-hand side, these are requirements of a contract to say, for this contract to be a valid and a binding contract, what does it need to have? First and foremost, it must have consensus. What does consensus mean? It means if we are entering into a contract, we must both of us be on the same mind. Both of us must know this is what we intend doing. So that is what it means when we talk about consensus. There's this misconception amongst people that for a contract to be valid and binding, remember, that is the very most important part that you must take away. A contract must be valid and binding. And thirdly, it must be enforceable in court. If you enter into a contract that is not enforceable, it's not a valid contract. Let's talk about capacity to enter into a contract. As you know, we've got minors and we've got majors. What is a minor? A minor in South African law, it is someone who's below the age of 18. Normally, there's certain contracts that you cannot contract if you are under the age of 18. You've got to do it with a legal guardian. 0 from 1 to 7 years, you can't contract. Somebody else, your parent or guardian, must sign. So that's the capacity to contract. And then we move to the formalities. Formalities means that a contract cannot only be in writing, it can be oral, or it can be by conduct also. So by mere conduct, then there's a contract. And then we've got legalities. For a contract to be a valid and binding, it's got to be legal, guys. Making an example, you cannot enter into a contract to bribe an official. Lastly, the contract, for it to be a valid and binding, there's got to be possibility of performance. Possibility of performance means if I sell you, I say we've entered into a contract for the sale of that phone, you must be able to deliver that phone. When I pay you, there must be possibility of performance. For a contract then to be void meaning it's cancelled, it's nothing. It's got to be acts of God. We enter into agreement today that I'm going to sell you my car. The car's there, outside. Tonight, there's a huge storm. The car is swept away. Then there is no possibility of performance because it is under no either of us that is the performance due. It's due to what is called acts of God. So those are the requirements really of what a contract is.
I've got two questions. The first one was regarding oral verbal contracts. Is there because in a written contract you can stipulate time periods and all that. Is there a time period for which it is valid, and then after which it's not? And my second question has to do with acts of God. Something like, using your analogy of a car being swept away. If a car is stolen before the time that the contract is supposed to be enforced, what happens then?
In terms of the time frames, in terms of the oral contract, obviously, it's up to you to decide in terms of the length of the time. The problem is if there's a dispute in terms of you say, no, we agreed on 3 years, and the other one says it was 5 years, then you've got to lead evidence in court to actually prove it. So if you were my client and I was advising you, I would actually say, have it reduced to writing, to avoid, disagreement. He said, she said.
The second question was about acts of God, where there's impossibility to perform. The possibility of non-performance must not be related to us. So if one of us can say, no, I know why that car is stolen, just because of you, then it's a different case. But in terms of formalities, it is always advisable that anything, whether it's your friend, whether it's your relative, whether it's somebody you know very closely, that you reduce it in writing.
What happens when, say, hypothetically, national policy would say the average person has to work 8 hours a day, Okay, and I signed a contract with a music company. Basically, the music company, it's I have to work 50 hours a week. And I signed it without recognizing. But while in the contract, I realized, Gusimusi, this is not, it's not complying with what the law says. And I've already signed. Well, what then happens? Can I challenge it? Or have I shot myself in the foot for signing that contract?
Sbongile wants to answer that question. Is it?
Yeah, I think Mande did touch on that when in his intro. That yes, that is one of the formalities. That the contract, for it to be legally enforceable, it must actually be legal. For it to be enforceable in court when there's a dispute. So, if the contract itself, what you have signed, does not fall within the realm of the law, then it's not worth the paper that it's written on. It wouldn't be enforceable in any event.
It is actually very important, which is something that we touched on. As you might have seen, some of the idols contestants, some of them are 16 years old. So we've got to advise them on things to look at in any contract so as to protect them, so that they are not taken advantage of by the bigger record labels, seeing that they are only starting up. Exclusive performance obligations. Exclusivity simply means when I enter into a contract with Sony, for example, it means that you sign your rights to them. You are going to be exclusively using them. You can't be with Sony, and then on the other hand, you with Afrotainment, or you cannot. You've got to, it means exclusivity to that record label. I think the critical part of all these principles for me, other than royalties, is the copyright of your music. Copyright of your music is about ownership of your music. Once you enter into a contract with that record label, it means basically, so long as you are signed with that record label, the music that you produce in that stable, it is exclusively and for their sole use. It's for them. I'm sure you guys understand that.
That's actually what I wanted to ask. Can you want to own the rights to your, to your own music? Would they allow it? Has it happened before?
Michael Jackson in point. He had so much money he could afford now to buy his own music. So you've got to reach a certain level before you can, everything's got value. Everything's got value. They'll put a value, they'll attach a value to their music and say, this is worth 50 million US dollars. Take it or leave it. So it's up to you to say, here's 50 million, I'm taking it. Because he knows the value of his own music. Should we move right along to royalties? Okay, royalties. This is where you guys get the payments for your music. It differs from record label to record label. Again, you cannot say so-and-so is getting 15% of the royalties and I'm getting 10%. It's about your own negotiations and your own status as a musician. What happens practically? Musicians, they accept even 5% because they want to what? Get into the industry. And then you get into the industry and your music is pumping, but you're not getting anything. But it is about your value. So you can't say now all of a sudden because I'm performing well, hey, let's renegotiate my contract before it expires. Can we move to advances? Before you do anything, upfront, they give you the money, boom. That money, guys, it is not free. It is an advance. Call it, it's like a loan. It's a loan. They're loaning you all these things, give you a G63, give you this, they give you that. It is about image in your industry. So it is important that you do not look at somebody else and say, Pap, they're getting so much, why am I not? It's a loan. It's going to come back via those royalties.
I'd like to know, what if you had an agreement with a certain studio, not recording label, that they'll provide you with like equipment to record, and you write the song yourself, you have your own beat, you can do your own thing, but all you just need is their studio. And then suddenly when you're done recording, they don't want to give you the song and they beat you to register it at SAMR. Like, what would then happen? Like, what's the procedure? Because you did everything for that particular song. However, they just outsmarted you.
Again, that's the importance of what Tebe was saying and Sbongile saying, is to have a good lawyer next to you. Never trust anything in the industry, guys. Even if it's your family member that's giving you that studio. Up front, you agree. How much is the studio? How many hours am I going to use it? Who's going to own that music? You agree on those things up front. And then what you do, you reduce them into writing. So don't wait until, guys, there's problems, then you start looking around. Where's the lawyer? If they do that, first of all, that's illegal. You can't just do that to somebody. But how do you protect yourself? By signing an agreement upfront.
I think in addition, you must try and as soon as possible, to establish ownership, you must copyright it. It must be registered somewhere that it belongs to you. Once you've recorded that album, copyright it so that it indeed legally belongs to you and nobody else can.
Confidentiality, guys, it's very important. It's a term that is almost in every agreement. Confidentiality. And it's something that I want you guys, even at this stage, to take note of, is that whatever you sign, where you see confidentiality, means that don't talk about it. Don't share it. Otherwise, you're going to be in breach of the contract. Confidentiality, first of all, applies both ways. You also don't want them to go and do the same thing. So it applies both ways. It's not about you only. Termination, guys, as we're about to wrap up, is when the contract comes to an end. It's simple as that. It will normally be defined in an agreement, because if we leave it as termination, anyone can interpret it differently. So it will normally be in the agreement that termination means this. That's when perhaps it will say, once you give me 2 albums, we terminate. It will always be specified. Just to wrap up, if ever there's one thing that we've talked about today, one thing that you must take is that before you sign, never plead ignorance. Make sure that you've read it, you've understood it, and you know what you're signing. So that's why it says, let the signatory beware. If in doubt on anything, ask. Thank you very much.
Gauging from the interest and the interaction, during our talk, I'm convinced that they have benefited a lot from the discussions that we've had. And I'm sure that they will ensure that, their rights are protected against vis-a-vis the record labels that potentially can exploit them if they do not get, adequate legal advice and their rights are not protected.